Hello everyone and welcome to our third legalities video. We're almost there now. Again, this will be very corporate sounding. Unfortunately, there's no way around it. However, unlike the last video, which was a bit on the long side, we'll be splitting this one into two parts, A and B. So let's get right on into it. This time around we'll cover the general conditions of sale. So let's get on section G1, the lot. Again, for simplicity, I'll just list the clauses and I'll elaborate further when needed. Clause 1, the lot, including any rights granted or reserved and any exclusions from it, is described in the special conditions. If not so described, refer to the sale of memorandum. This means that anything to be granted by the lot, if not included in the particulars, will be in the sale of memorandum, which is the signed contract. Clause 2, the lot is sold subject to any tenancies disclosed by the special conditions, but otherwise with vacant possession on completion. This simply means that if a lot is tenanted, you will be made aware. Clause 3, the lot is sold subject to all matters contained or referred to within the documents. The seller must discharge financial charges on or before completion. A mortgage is one example of this. Clause 4, the lot is also sold subject to any of the following that may affect it, whether they arise before or after completion, contract date rather, and whether or not they are disclosed by the seller or are apparent from inspection of the lot or documents. A, matters registered or capable of registration as local land charges. B, matters registered or capable of registration by any competent authority under the provisions of any statute. C, notices, orders, demands, proposals and requirements of any competent authority. D, charges, notices, orders, restrictions or agreements and other matters relating to town and country, planning, highways or public health. E, rights, easements, quasi-easement and way leaves. F, outgoings and other liabilities. G, any interest which overrides under Land Registration Act 2002. H, any matters that ought to be disclosed by the searches and enquiries a prudent buyer would make, whether or not the prudent buyer has made them. And I, anything the seller does not and could not reasonably know about. On to clause 5, where anything subject to which the lot is sold would expose liability to the seller, the buyer is to comply with it and indemnify the seller against said liability. This means that if the seller would be liable for something, the buyer must alert them of that. Clause 6, the seller must notify the buyer of any notices, demands, orders, proposals and requirements of any competent authority of which it learns after the contract date, but the buyer must comply with them and keep the seller indemnified. Clause 7 is about cattle in particular, so seeing as our auction house at present doesn't have any available, I'm not going to cover this section to save time, but if you need to see it, I implore you to give it a read over yourself. So on to clause 8, which is as follows. The buyer purchases the lot with full knowledge of A, the documents, whether the buyer has read them or not. B, the physical condition of the lot, and what could reasonably be discovered upon inspection of the lot, whether or not the buyer has inspected it. And clause 9, which finishes this section off, the buyer admits that they are not relying on the information contained in the particulars, or on any representations made by or on behalf of the seller, but the buyer may rely on written replies from the seller's conveyancer to written inquiries to the extent stated within. Now, section G2, the deposit. Calculations for the deposit are the same as the last video, no changes there. However, this section makes it very clear that a seller can claim against you, the buyer, for breach of contract if check or other payment method agreed upon by both parties partly and or completely fails to clear. And on to section G3, between contract and completion, starting from clause 1. From the contract date, the seller has no obligation to insure the lot, and the buyer bears all risks of loss or damage unless A, the lot is sold subject to a tenancy that requires the seller to insure the lot. B, the special conditions require a seller to insure the lot. Clause 2, if the seller is required to insure the lot, then the seller must A, produce to the buyer, on request, all relevant details. B, must use reasonable endeavours to maintain that or equivalent insurance and pay the premiums when due. C, gives no warranty as to the adequacy of the insurance. D, must at request of the buyer, use reasonable endeavours to have the buyer's interest noted on the policy. if it does not cover a contracting purchaser. E. Must, unless otherwise agreed, cancel the insurance upon completion, apply for a refund of the premium, and subject to any rights of any tenant/third party, pay that refund to the buyer. F. Also subject to the rights of any tenant/third party, hold on trust for the buyer any insurance payments that the seller receives in respect of loss or damage arising after the contract date, or assign to the buyer the benefit of any claim. The buyer must also reimburse the seller the cost of that insurance as from the contract date, paid by unless paid by a tenant, the buyer, or a third party. Clause 3. No damage to or destruction of the lot, nor any deterioration in its condition, however caused, entitles the buyer to any reduction in price, to delay completion, or to refuse to complete. Section 47 of the Law and Property Act 1925 does not apply to the contract. Clause 5. Unless the buyer is already in lawfully occupation of the lot, the buyer has no right to enter into occupation prior to completion. And after that clause, that finishes off part A of this video. Be sure to join us for part B, it will be up within the next week or so. And have a good day, everyone.